Good afternoon and welcome to the Environmental Law Institute. You have joined us for Basics of the Clean Water Act. My name is Caitlin McCarthy and I'm the Director of Education, Associates, and Corporate Partnerships here at ELI. We're delighted to welcome everyone today to the third session of ELI's annual summer school series, and I encourage you to join us here at ELI every Tuesday this month and next, but not the week of Independence Day, for summer school. For more information, please see the events page of our website, eli.org. Thank you for joining us. At the end of today's panel, we will have time for a question and answer session. If you are joining us in the room, we will have this microphone to bring around at that time. And if you are joining us via GoToWebinar, we ask that you enter your questions through GoTo's question box. And please do not save your questions until the end. Send them as soon as you think of them. I would also like to thank our outstanding panelists for joining us today to lend their expertise to summer school. While I will introduce them briefly momentarily, the full speaker bios are posted on our website, eli.org, and we encourage you to check out their expertise and experience in more detail there. As we begin, I would like to briefly introduce our panelists. Joanna Citron-Day is an attorney with the Environmental Enforcement Section of the Department of Justice. At DOJ, Joanna focuses on the regulatory enforcement of major federal environmental statutes, including the Clean Water Act, Clean Air Act, and CERCLA. Prior to DOJ, Joanna was an attorney advisor at the Department of the Interior, and prior to DOI, an attorney at EPA. We're glad you're here, Joanna. Kathy Robb is principal at Sive, Padgett, and Rizal, where her practice focuses on environmental litigation. Kathy represents water districts, developers, investors, lenders, companies, and chemical manufacturers on water-related disputes, endangered species issues, environmental impact reviews, river sites with contaminated sediments, solid and hazardous waste issues, as well as sites with contaminated groundwater, among others. Kathy, we're glad to welcome you back to summer school. Amanda Waters is the General Counsel for the National Association of Clean Water Agencies, where she oversees and manages the legal advocacy program and strategic communications, as well as advises on legal and policy issues. Prior to NACWA, Amanda was the Government Affairs Counsel for the Water Environment Federation. Amanda, thank you for joining us again. With that, I will like to warmly turn things over to Joanna to get us started. Thank you.
Okay. Thank you so much. All right, well, we will try to keep this fun and interesting, even though it's sort of a long PowerPoint. But welcome, everyone, and thanks for coming. Again, I'm Joanna Citron-Day from Department of Justice, and we'll jump right in here. So I'm going to be covering the basics overview of the Clean Water Act, kind of a little bit of the structure, history, how the Act works, and you're going to see as we go forward that both Kathy and Amanda are going to revisit some of the pieces that I'm going to cover initially in some additional detail. So the Clean Water Act has been around for quite some time, 44 years in fact, and yet many waters do not meet water quality goals. It's an ongoing challenge. There are a lot of reasons for that are, I think, very complicated, but I think that the long and the short is that there has been a lot of great work done under the Clean Water Act, and we still have a long way to go. What are major sources of water pollution? There are a lot of ones that you would think of, and then maybe some ones that you might not think of. There's the typical, you see the big pipes from industry, industrial point sources, stormwater, which can, come from construction sites. It can be runoff from highways. You see all the cars. CAFOs, consolidated animal feeding operations, agricultural sources, see the picture of the cow, tractors, etc., and many others, nutrient runoff, and of course there's non-point sources, which the Clean Water Act primarily started focusing on point sources, but more and more has tried to address a lot of the non-point source pollution, and again, I'll touch on that, but you'll hear more about that later in the presentation. We connect with water. Why do we care, right? Because people care a lot about water, more than we have, in quite some time. Americans are more concerned about water pollution than they have been since 2001. And worrying about pollution of drinking water, worrying about other pollution sources, it's all connected, quite frankly, right? Because water doesn't just stay in one place, it moves. and it's connected. So when we're talking about the Clean Water Act, which is navigable waters, and when you think of oceans, rivers, lakes, you know, the big things, there are drinking water uptakes there. There are other things affected that may be regulated under, for example, the Safe Drinking Water Act, but there's a lot of interplay between the regulatory framework and between federal regulation and state regulation. So what will be covered in my portion of the presentation? I'm going to get into a little bit of the history, goals, and framework of the Clean Water Act. What are the substantive provisions, particularly the prohibition elements, water quality, which is the thing that we're all trying to achieve, permitting and restriction on discharges to try to achieve water quality, and then enforcement, which is largely, I'll be talking about NIFTYs, the permitting program and the enforcement under NIFTYs. So a brief history of the Clean Water Act. There's more than just what's on this slide, but I tried to keep it short for the purposes of being able to get through the material. Where did the Clean Water Act come from? Well, originally in 1899, the oldest environmental statute that we have in the United States is the Rivers and Harbors Act, which was administered by the Army Corps of Engineers, and now much of it is covered within the Clean Water Act, and it essentially was aimed at prohibition of obstruction and attenuation of navigable water. So not really the same purpose that the Clean Water Act has. And after the Rivers and Harbors Act, you moved into the original Clean Water Act. It wasn't called the Clean Water Act then, the Federal Water Pollution Control Act, which is actually still the proper name, in 1948, which added some additional elements, technical assistance, grants, other things, but there were still a lot of issues as evidenced by those two pictures. You may have heard about the famous Cuyahoga River, which caught on fire several times, and I think that picture is from 1952, and this was due to just a lack of regulation of industrial sources, other sources of pollutants, point sources, discharging into navigable waters, and unfortunately that's one of the things that happened. And the lower picture is the Storm King Con Ed project, and there was a lot of opposition to that from the Hudson Preservation Council based on concerns about essentially fish populations being killed and environmental concerns, other concerns. So there was a shift towards essentially a more robust Clean Water Act. And so looking to 1972 and 1977, public concern heightened, a lot of other factors came into play, and ultimately the Clean Water Act as we know it was amended again in 72 and 77. There were also some additional large amendments in 1987. It's administered by US EPA's Office of Water in partnership with states, which is called cooperative federalism. And we'll also get into that a little bit more. But essentially you have the overlay of the federal government, and most states are what's called authorized states, and they will be the primary permitting authority by which the Clean Water Act essentially accomplishes its goals and regulation is accomplished. So what's the goal of the Clean Water Act? To restore and maintain the chemical, physical, biological integrity of the nation's waters by, among other things, eliminating the discharge of pollutants without permits into navigable waters of the United States. Well, that's a real mouthful, isn't it? What does that really mean, right? We want to make sure that our water is not full of pollutants, not catching on fire. We're able to drink water we want to drink, fish in water we want to fish in, swim in water. And essentially what the Clean Water Act does it gives permits to pollute. That's the without permits is the implied. So essentially, again, the modern Clean Water Act as we know it through the 1972 and 1977 amendments led us to this goal, which is really twofold, where you have elimination of discharges as the first piece, and then achieving water quality levels, which often are referred to as fishable, swimmable, but how we want to use water without restriction, essentially, is what we're trying to achieve. So the basic framework framework, sorry, of the Clean Water Act. Can't speak today. And this is very, very, very simplified for the purposes of the overview piece of the presentation. You have water quality standards, which are established for all contaminants in surface waters. And so what are water quality standards? They are aimed at achieving the desired condition of a water body to be achieved and the means by which that condition is protected or achieved. Then you have the NPDES program, which is the permitting program, National Pollutant Discharge Elimination System program. And so you have these permits to pollute, which regulate the discharge of pollutants into waters of the United States from point sources, which is really the heart of the Clean Water Act. It makes it illegal to discharge without an NPDES permit. You also have pollution control programs that implements pollution control programs, for example, setting wastewater standards for industry. So there are just a variety of sector-specific areas where there are specific controls that then ultimately are integrated into the NPDES program to achieve water quality standards. Another support beam, I would say, of the Clean Water Act framework are construction grants to fund construction of sewage treatment plants. And I think Amanda's going to get a lot into the municipal program, which is just large, expensive, it's complicated, and in addition to things like enforcement, which is where people like me come in, there are a lot of, excuse me, other pieces to help support this program, which is extremely important and expensive, and you need a lot of pieces to help fund it. Non-point source programs. There was a need to address that. That was recognized. I think as the Clean Water Act has matured, there has been additional support for that particular area, which I think has been hard to grasp and regulate. But again, Kathy and Amanda are going to get into other pieces such as the MS4 program, stormwater permitting, things that are aimed at these more disparate sources of pollution like stormwater runoff from construction sites that are not the traditional point sources that the NPDES program covers. So how is the Clean Water Act framework implemented? EPA are authorized states, there's 48 authorized states now, establish water quality standards for particular water bodies, list impaired and threatened waters. Those are waters that are not achieving the water quality standards that have been established. Establish monitoring and management programs, develop TMDLs, which are total maximum daily loads, to protect water quality, issue permits to point sources to ensure that water quality standards are achieved, and that's the NPDES program. And that's there are a variety of standards in NPDES permits, and we'll get into those in a little bit. Again, funding infrastructure, for example, money to help build bigger treatment plants, larger pipes, things of that nature to support the goals of the Clean Water Act, and programs to manage non-point sources, which I was just talking about. So examples of key Clean Water Act amendments. This is, again, just a small sample because there have been many, many more. 1977, I think the important piece there is the focus on toxics and rewriting deadlines because, excuse me, the need to make sure that, water quality objectives, water quality goals are achieved, is not some far out goal. It's something that is critical, and we want to make sure, and the Clean Water Act tries to make sure that it's achieved in a timely fashion, which the jury's out on that. 1981, municipal grant program overhaul, treatment plants. Again, these are programs to, I think, fund important infrastructure pieces that are a key part of what the Clean Water Act covers. 1987 is really, there is a lot that happened in the 87 amendments: municipal grant programs, strengthening enforcement penalty authorities, toxic control strategies, non-point source program, and the stormwater program. And there have been a lot of other special purpose amendments, which in my mind, there's a lot of categories of these types of amendments. Some of them are kind of general categories like, for example, the CSO policy, which again relates to a lot that Amanda's going to be talking about with the wastewater treatment part of the NPDES program, but codifying that, and then the Water Infrastructure Finance and Innovation Act are sort of aimed at balancing the sometimes not conflicting, but competing objectives of, okay, we want to achieve water quality standards, but how do we pay for that? And cities, trying to, conserve and use their resources wisely. Then there have been specific geographic aimed amendments. For example, a lot of you may know about the Chesapeake Bay. There are specific requirements related to nitrogen and other specific parameters there. Also in the Great Lakes area and Long Island Sound, Lake Pontchartrain, just to name a few, where there are specific waterways throughout the country, and we often call it impaired waterways 303D, which is the section of the Clean Water Act that covers them. There are specific additional, often more stringent parameters to try to achieve the water quality standards there, because they are not being met. So Clean Water Act Section 301 has the basic prohibition. Except as in compliance with the following sections of this title, the discharge of any pollutant by any person shall be unlawful. Essentially, you need a permit to pollute. That is the heart of the Clean Water Act. And point sources, getting permits, is really a lot of what the Clean Water Act does and how it regulates water bodies and attempts to achieve its goals. So the elements of Clean Water Act 301 are extremely important, and quite frankly, each one of these elements is something that we're all going to cover in different ways, and are critical to essentially how the act is carried out, how it's enforced. The discharge of a pollutant by a person from a point source or dredge or fill material into a water of the United States, except as in compliance with listed permitting programs, 402, 404, which is dredge and fill material. And there's additional detail in the NPDES implementing regulations, which is 40 CFR Part 122. And the key definitions, which we're going to go through, are all in 40 CFR Part 122. So what is a discharge? Any addition of any pollutant or combination of pollutants to waters of the United States from any point source. It covers a lot, and a discharge, you'll see each one of these elements, I would say, is a fairly broad definition. And again, both Kathy and Amanda are going to get into aspects of each of these elements as well. Of a pollutant. So that's the list: dredge, spoil, solid waste, incinerator, residue. I won't go through all of them, but it's things you think of, things you don't think of, things that can be seen, things that can't be seen, heat, for example, things that change the water quality. And as you see there, the two different colors, that is for oil spills, for example. That is one way that if there's a sheen, that is a measure of, whether or not there has been a discharge of a pollutant. By a person, an individual, association, partnership, corporation, municipality, state, federal agency, agent, or employee thereof. So person is also extremely broad. Again, the municipal enforcement program, we're dealing with cities, municipalities, governments, people, companies. There's a lot of things, entities that fall under the definition of person. From a point source. This is also meant to be intentionally broad. It's not just the end of a pipe. It's any discernible, confined, discrete conveyance, including but not limited to. And again, I won't read all those off the slide, but there are some important exclusions: agricultural stormwater discharges, irrigation return flows, and non-point sources. And I'll talk about point sources, non-point sources in just a couple of minutes. But the point being that if you can identify it as a point source under this broad definition, you need a permit to be able to discharge pollutant into navigable waters, into waters of the United States. Into a water of the United States. And I will let Kathy cover this in a lot more detail, but this is just the first intro to it again, which is the regulatory definition. Essentially what you would think of as traditionally navigable waters is a term that people use, which can be waters that are used, were used, or may be susceptible to use in interstate or foreign commerce stuff. Can you put a boat in it? That kind of thing. And again, there's a bunch of other categories in there, but we're going to return to that later in the presentation. So what is a point source? Again, it's what you would think of. It's the end of a pipe, but things you might not think of, coral reefs, that's a point source. Oyster beds, which is that top middle, the plane dropping, I think that's a plane dropping fertilizer. This is one slide I borrowed from Kathy, but I'm assuming that's what that is. Yeah. A vessel, that's a big ship. So there's just a lot of things. The upper right is, I think that's probably a sewage overflow. That's a manhole cover. So it covers more than what you might think of. What is a point source? Any discernible, confined, and discrete conveyance, including but not limited to. Again, these are meant to be very broad definitions because the point is we want to make sure that we are regulating point sources that are introducing pollutants into navigable waters, because if we're not, then we're not going to achieve water quality goals, and that's the whole point here. So from which pollutants are or may be discharged, which is again another important, that makes it even broader, because even if a point source is not currently discharging, if it may be discharging, and what happens in the context of the permitting scheme is that you're going to have to identify that in your permit application. The municipality, the company, whoever the permit applicant is going to have to say, well, I may use this, I use the word pipe, but I may use this point source, and so therefore it has to be listed as potentially a discharge point. So non-point sources, it's essentially everything else. So non-point sources aren't defined in the Clean Water Act, and again, Amanda's going to cover more on this, but a non-point source, it includes fertilizer, pesticides, I think I was talking about runoff, this can be energy production, construction sites, stream banks, there's a lot of different things, atmospheric deposition, there are a lot of different things, and it is, I think, a challenging area because a lot of pollution comes from non-point sources, and it is just much more difficult to regulate because getting your arms around what's covered and how to regulate it has been an ongoing challenge of the Act that I think regulators are continuing to try to improve upon. 303, which is water quality standards, which again is one of these key framework pieces of the Clean Water Act, which is what we want to achieve here is good water quality. And so states and tribes must adopt water quality standards. EPA then approves or disapproves, and a state tribal water quality standard takes effect only after EPA approves it. And EPA can issue a water quality standard if a state or tribe fails to do so. And that, again, that's all for, authorized states and tribes. And that's pretty much almost everyone. It's the legal basis for controlling pollutants entering into waters of the United States. Again, achieving water quality standards. I know it seems like a lot of repetition, but water quality standards are such a heart of the Clean Water Act. And we're wanting to protect designated uses. What is that? You hear people use the phrase fishable and swimmable, but those are two examples of what are a sort of a larger list, typically protection of fish, wildlife, recreation, drinking water, because again, though we also have the Safe Drinking Water Act, water is connected, it flows, it's not static, and so water that's regulated by the Clean Water Act may ultimately flow down, and you're then going to also have the intersection of the Safe Drinking Water Act. Agricultural, industrial, and navigational purposes is another designated use. And the water quality standard regulations are at 40 CFR Part 131, and that establishes requirements for states and tribes to review, revise, and adopt water quality standards, and the procedures by which EPA reviews and approves water quality standards under Section 303C of the Act. So water quality assessment and reporting. Water quality standards are not just static there is an ongoing analysis and revisiting of are water quality standards for a particular water body appropriate? Do they need to be changed? So there's a state monitoring network, there's a biennial report pursuant to 305B and 303D. There's an assembling of all the data, assessment methodology, a 303D list of impaired waters, and then prioritization. Total maximum daily loads are based on, okay, what is the state of this water body? Are we achieving water quality? Is it an impaired? Is it a 303D listed waterway? Do we then need more stringent standards where you can't have as much pollution? And so total maximum daily load is the total amount of pollution that a water body can withstand, essentially. And then the permits carve out pieces. And together, you can't exceed the total maximum daily load. So if you think of it that way, that's kind of a helpful way to think of it. So restrictions on discharges. We have water quality-based limitations. So there's three pieces of water quality standards, three components. The designated existing uses for a water body, which I was just talking about, the narrative and numeric criteria to protect the designated uses, and anti-degradation policy to maintain high quality waters. And again, that kind of goes part and parcel with the impaired waterway designation. For 303D listed waters, you're going to have even more stringent regulations. But I'll get into the narrative and numeric criteria a bit in a minute. And with more stringent regulation, this is under 301B1C, you can have a more stringent regulation that includes something that's necessary to achieve a water quality standard, again, for 303D listed waters, necessary to meet schedules of compliance. If there's a court order, if there's a consent decree in place that says that an entity has to achieve a certain standard by a certain date, pursuant to state law, other federal law regulation, or required to implement any water quality standard established. So there's also technology-based standards, which is another type of restriction on discharges. And this is under 301 and 304, which are criteria, stating what the effluent limitation regulations shall contain. And there's mandatory technology-based requirements depending on industrial categories. And there are 67 industrial categories, and you can look all of this up. Anything from cement manufacturing, coal mining, construction, landfills, things you would think of, but then there's things you might not think of. Like there's the, I can't remember what the dental one was, but there's one from, their dentist's office is one, so that's kind of an interesting, fun one. And this is also, again, something Amanda's going to get into something more in her part of the presentation. And NIPD's permits are for direct dischargers, and there are permits, there are other control mechanisms for indirect discharges, the pre-treatment program, which also, there are additional permits there, but that's kind of sort of an additional level of detail. So Clean Water Act permitting, 402 is the primary permitting piece that I would say covers a lot of the NIPD's program. 404, also an important part of the Clean Water Act. Kathy's going to get into more detail on that, and that's the dredge and fill, that's the filling in wetlands and those types of permits, which is a different area. But the point sources under 402 is a big part of the NIPD's program, and 48 states have authorized NIPD's permit programs. This map, which I think we weren't able to find, a more recent one, doesn't include Idaho, which is now authorized, but you can see there are different levels of authorization, including certain programs, biosolids, but that's mostly up to date. The EPA has not put up a more recent map than that. So NIPD's permits under 402. EPA may authorize states to administer NIPD's program, and again, 48 states are authorized to do this. So what does that mean? That means that a permittee, whether it's a city, whether it's an industry, you know, whether it's a cement facility or glass manufacturing or dentist office or whatever it is, will apply to get a permit to pollute. And if it's an authorized state, then the applicant goes to the state, and the state has to provide opportunities for the public to comment on permits. And obviously for the unauthorized states, that goes directly to EPA. But EPA retains oversight. The state is the permitting authority, is the primary, the issuer and enforcer of that permit, but EPA does not go away in the program. There's a chance to review draft permits and object if the permit isn't as stringent as federal law requires. EPA can object to a proposed state permit, and they can revoke a program for cause, a permit program for cause. And there's also the potential for overfiling if EPA feels that a state is not doing all it can to enforce its permit program. I don't know that EPA has ever revoked a permit program. I don't know if either of you, I don't think they have. So it's a potential, but just a side note there. So narrative and numeric criteria. These are sort of key pieces of NIFTY's permits that make up how point sources are regulated, how the pollution is regulated. So narrative is not a number, essentially. It says surface water shall be virtually free from floating non-petroleum oils of vegetable or animal origin, as well as petroleum-derived oils. I will say, as a regulator, narrative standards can sometimes be a little challenging because you can have a lot of disagreement as to how people interpret narrative standards, but they are important nonetheless. And there are, ones that the feds come up with. These are examples of EPA standards, but then states will come up with their own as well. And so you see permits really look different from state to state, depending on that particular state's interpretation of both narrative and numeric criteria, because even how numeric criteria are issued in permits is different from state to state. The ambient water quality criterion for cadmium is recommended to be identical to the existing drinking water standard, 10 micrograms per liter. So that's a number, but even the number can be sometimes confusing and difficult to interpret. Is it, the measure of the number? Is it per day? How often you monitor it? It's seemingly straightforward, but again, I have been involved in many a spirited discussion about interpretation of a numeric criteria. Reporting requirements. Again, this is another piece of permits. So you have to meet a narrative standard, you have to meet numeric standards, and then there are reporting requirements that are required to comply with NIFTY's permits. So DMRs, discharge monitoring reports, are instances of non-compliance have to be reported. A lot of states now, I would say, post this information to their website. It's often publicly available. In many states, or entities sometimes will issue information requests, freedom of information requests to get this type of information. Changes in discharges, if you're increasing the volume of a discharge, if you're discharging something that you're not permitted for, you have to let the regulator know. If there's an upset or a bypass, if the normal conditions under which the permit was issued are not met, that has to be reported. There's a duty to provide information and a right of entry, meaning for an authorized state, it would be the state entity, but EPA also always retains the right to inspect, to say, hey, we're not sure if you're complying with your permit, we have questions, we're gonna come check things out. And there may be the need for additional monitoring or special studies. So Clean Water Act enforcement, federal and state. Way back, one of the early slides talked about cooperative federalism. So EPA, the federal government and the state governments work together to enforce the Clean Water Act. And 308 is a very powerful tool. It's the information gathering tool under the Clean Water Act. And people usually think of 308 as an information request where you send a written request for information and you ask about, things that you have questions about, if you have suspicions that an entity is not complying with its permit. But an important note about 308 that I wanted to make is that it's monitoring and information gathering, meaning you can ask for information, but regulators can also ask for a permittee to monitor, to actually do things, to gather information that then has to be reported back to the regulator, not just provide information that's already on hand. So 308 is a broad authority. And a lot of the basis for enforcement actions sometimes come from information that's gathered in the course of 308 authority. And 309, which is enforcement. Injunctive relief, civil penalties, those are huge areas. I have two very small bullets. But the injunctive relief is just going to vary widely. It's difficult to generalize because if you're dealing with an industrial site, and even within that, there's all the categories of industrial sites versus a municipal entity. There are so many different things that we do for injunctive relief under the Clean Water Act based on the particular type of discharger, the particular type of violation. There might be additional treatment. In the case of a municipal case, you might say build a new treatment plant, build a bigger treatment plant. I just had an industrial stormwater case where we had the industrial discharger do additional treatment. They also had to hire additional personnel, do additional training. So that there's just a wide variety of things that can be done. And civil penalties are statutorily mandated, and those are essentially to pay for the past violation, the period of time during which you were violating the act prior to the enforcement action. So permit as a shield defense. This is Clean Water Act 402K. Compliance with a permit issued pursuant to this section shall be deemed compliance for the purposes of state and federal enforcement and citizen suits, except any standard imposed for a toxic pollutant injurious to human health. So essentially, if you're complying with your permit, that is a defense. That is something that you can say, look, you know, there might be some sort of injury to the water body, to the water quality standard, or there might be a problem, but if you're complying with your permit, that is a defense. But if there are toxics involved, that also is something that then cuts against the permit as a shield defense.
Joanna, can I add something
Sure.
on the permit
Sure.
shield? So this came up in a case several years ago where what we're seeing across the country are NPDES permits that have language. They'll have your effluent limits, and then they'll have a catch-all boilerplate that says, and all discharges shall comply with water quality standards, or something like that, a catch-all. And so some environmental groups have brought suit under that provision saying, okay, well, we found this in your discharge and it contributes to water quality standards violations, therefore you're liable. And the permitted entity was going back to their permit saying, well, we didn't have any specific limits here. But that language in there seems to provide an avenue to make a permittee pretty much responsible for compliance with all water quality standards. So this is something that we've been working with our municipal members to look for in their permits, because there should be a process for determining what water quality standards have, where you have a reasonable potential with your discharge to violate water quality standards. They're not independently enforceable end of pipe. There should be a translation based on whether there's reasonable potential, because you have dilution. You have the ability to discharge into a water body where there's more than just that pollutant, and you should be able to take advantage of that in that analysis to determine if you're actually violating the water quality standard. So the permit shield defense, I think, has been seriously curtailed by the widespread inclusion of this language in permits. There's a Fourth Circuit case, it was called FOLA, that ruled that yes, this provision is applicable, and they are bound by it, and ruled that in this case, it was a coal company had violated it.
Okay, thanks for that. All right, so I'm going to try to wrap it up because I think I just got the 3-minute before. So federal versus state enforcement. Overfiling. This is something where federal enforcement is not barred by state enforcement, and it's intended to promote consistent enforcement of federal regulation. As I said, I mean, the permits, particularly in authorized states, don't all look the same, and I think that even for permits looking the same, reasonable minds can differ. Sometimes the state will say, you know, okay, the DMRs, there are violations, but we're going to choose not to pursue an enforcement action, but EPA is going to disagree and say, no, we think that we should, you know, this involves an impaired waterway or some other reason. We think there's a public health issue here. We want to move forward. So when there's an imminent hazard, states fail to take timely and appropriate action, or a state has requested that EPA take the lead. I've also been involved in cases where there's so many reasons this happens, political reasons, resources, states have, you know, limited resources, and they say, hey, we've tried to issue some notice of violations, we've issued some penalties, this entity is not complying with its permit. EPA come in, EPA will then refer the case to Department of Justice. We will file a complaint in court, or we will try to reach a settlement agreement and then, enter a federally enforceable consent decree and hopefully get that entity back into compliance with its permit. Underfiling, and I would also, just as a side note, overfiling is somewhat rare. I mean, again, Clean Water Act operates with cooperative federalism. There's a lot of cooperation between the federal government and state governments, and that's also specifically called out in Section 309. But underfiling is very rare, I would say. States have a different remedy than EPA, or they might be seeking more stringent damages, but it is a very, very rare. I also have not seen underfiling, and I don't know if Amanda and Kathy have ever seen it. So that's just to point that out for people that have been doing this for a lot of years. Civil penalty, I'm sorry, did I skip a slide? Civil penalties, which are statutorily mandated, and they're adjusted annually beginning in 2015 for inflation. There's per day violation, and these are for the past inflations. Essentially, when EPA refers a case to Department of Justice and we bring an enforcement action, there's a calculation done, and you say, okay, this many days, you add up the violations, usually 5-year statute of limitations, and you come up with a number for civil penalty payment for past violations. And then if you're entering into a settlement, you may say, okay, we will look at one of our settlement penalty policies to potentially reduce that number, and then you can negotiate stipulated penalties, which would apply moving forward during the course of the consent decree, during the course of the settlement agreement. I just briefly wanted to mention 311, because the oil spills are an important piece of the Clean Water Act that's not under the permitting regime, but there are penalties specifically for oil spills, and these can be big money penalties. 311B3 and 311J is SPCC related to, containment of oil adjacent to navigable waters. Okay, so citizen suits, 505 is the express statutory cause of action against any person, which can include the government for non-discretionary duties, but that are in violation. There are a fair amount of limits on citizen suits. You have to file 60 days notice of intent to sue. So to the federal government, to the state government, to the violator, you have to provide that notice. And if the federal government, state government says, look, no, we're gonna move forward on this, which also happened. I've had that happen multiple times. There's what's called a diligent prosecution bar. So then that temporarily will stop the citizen suit from proceeding, but a citizen group can still try to intervene, and they may be able to get into an enforcement action that way. And I think we've all probably been involved in cases where there have been successful interventions. So citizen suits, I would say, are an important complementary piece of the enforcement regime. And there's a standing requirement as well. And settlement penalties and attorney fees are what under 505 you can get for citizen suits. So with that, I will wrap it up and hand it to Kathy.
That's the clicky thing.
Sure.
Thank you. That was great. Thank you, Joanna. And let me just say that for every bullet, there are like lines of case law for every single one of these words. So we're trying to hit the highlights today, but I just want you to be aware. And I want to thank all of you for coming today and everybody who's listening remotely. I'm going to be talking exclusively about the 404 permits under the Clean Water Act and jurisdictional waters. What does waters of the United States mean, if we can figure that out in 15 minutes together? And the Section 401 state water quality certifications. First, let's talk about 404 permits. Joanna spent a fair amount of time setting the stage on the 402. Some people say NPDES and some people like me say NPDES, and it sort of depends on where you grew up and how you were taught, but it's all the same thing. But there is another very important permitting program under the Clean Water Act, and that is the 404 dredge and fill system. And Amanda's going to also talk a lot more about especially 402 when she comes up next. Unlike the 402 program, under 404, there are only 2 states that are delegated, and these permits are therefore mostly issued by the Army Corps of Engineers. The Corps consults with EPA closely on 404 related matters. They issue the permits for the discharge of dredged or filled material into waters of the United States under the Clean Water Act. The Corps makes the jurisdictional determinations about what is waters of the United States. And instead of saying that 400 times in the next half an hour, I'm going to say WOTUS. The Corps makes the jurisdictional determinations under WOTUS, and they're made according to joint EPA Corps guidance. And we're going to talk next about what WOTUS might mean. EPA has the authority to review and object to 404 permits, should it wish to do so, if they believe that the permit will have an unacceptable adverse effect on water supplies, fisheries, wildlife, recreational areas. This is used pretty rarely. They've only done it about 13 times since the Clean Water Act was instituted in 1972, so it doesn't happen very often. So under 404B1, the 404 permit analysis requires you to avoid, minimize, or compensate for impacts to water from dredge or fill material. Avoid means that you have to ask yourself, is this the least damaging practical alternative for doing my activity? Minimize means if it's not avoidable, then you have to take steps to minimize your impacts, either, for example, by a project modification or permit conditions. And in addition, that you have to compensate. You use compensatory mitigation for unavoidable adverse effects. So what does dredged material mean under 404? It means material that is excavated or dredged from waters of the United States. So that's the stuff you take out. Fill material means material that's placed into WOTUS, where the materials have the effect of either replacing a portion of a WOTUS with dry land. So if you're going to fill in a wetlands, or change the bottom elevation of any portion of WOTUS. And don't forget, before there was ever a Clean Water Act in the gleam of anybody's eye, there was the Rivers and Harbors Act of 1899, and the Corps originally was dredging the navigable waters of the United States so the boats could go. And so a lot of the 404 program has its origination in putting in piers, dredging the rivers. That's how it got started. So examples of fill material can include rock, sand, soil, clay, plastics, construction debris. Fill, by definition, does not include trash or garbage. And in addition, there are some exceptions to fill material and dredge material, like certain farming and forestry activities are exempted, like plowing, food cultivation, seeding, that sort of thing. So we apply compensatory mitigation to restore, for the restoration, enhancement, and establishment to offset the permitted losses of jurisdictional waters and wetlands. And this is to support the national goal of no overall net loss for wetlands. There are 3 compensatory mechanisms that are used to do this. One's called mitigation banking, one's called in lieu fee mitigation, and one is called permittee responsible mitigation. Now, when all of this started, the Corps favored permittee responsible mitigation on site, but it turns out that that's often not practicable. And so these other avenues are more recent. Oops, sorry. Okay, so first is the mitigation banks. A mitigation bank is created by a bank sponsor who sets up a restored, created, or preserved wetland, stream, or another aquatic resource. And the value of that resource is determined by quantifying the functions that are restored or created. And those are called credits. And then the permittee buys the credits and mitigates for whatever activity on site has resulted in a loss. And this is just a pretty simple schematic from the Army Corps of Engineers. I love that little logo with the castle. That tells about mitigation bank. There are hundreds of these on the website. A lot of them are extremely impenetrable flow diagrams, but they're all very useful in figuring out what it is that you're trying to do with the Corps, and you might want to just Google them sometime. So then, in addition to bank, there's in lieu fee programs. Now, the permit applicant pays a fee that to a program that it's administered by a public agency or a nonprofit, which is the distinguishing feature from the banks. And there's an agreement put into place between the in lieu fee program and the regulators to collect these fees from the permittees and use them to restore or create wetlands, streams, or other aquatic resources. Then the final one is the permittee responsible mitigation, where it is what it says. The permittee implements the compensatory measures at the site, which is called on-site mitigation, or in the watershed, which is off-site mitigation. And as I said, those are most favored, but often not practicable. So that's the individual permitting program and compensatory mitigation under 404. Now we're going to turn to nationwide permits, which are a very important part of the 404 program. The nationwide permits constitute 97% of the Corps' workload. And what these are generic, general permits that are published periodically every 5 years, and they're issued for categories of work. And when they issue a nationwide permit for a category of work, and you can fall within the permit, you do not have to get an individual permit, which can be a big deal in terms of time, cost. A lot of people use nationwide permits. There are currently 54 of them. They were last promulgated in 2017. In 2017, they added 2 new ones. There used to be 52. They're usually covering minimally impacting activities, and most of them require that you give pre-construction notification, or PCN, to the Corps before you use one. But 19 of them, of the 54, do not require PCN. And they're good from 5 years of issuance. They're for use for actions by private landowners and for actions that are similar in nature and will likely have only a minor effect on wetlands. If you do not comply with the conditions of the general permit, you risk an enforcement action. And that is a lot of how the nationwide permits are tracked. And there's paperwork involved that you have to file in order to use one of the nationwide permits. An example would be for minor road activities or a utility line backfill. But you can, the list is on the Corps' website, and you can read all about them. The two new ones that they added were for removals. Number 53 is removals of low head dams, but 53 does not authorize building a new dam, just authorizes taking down the old one. And 54 is for construction and maintenance of what's called living shoreline, shore erosion control methods. Those have to be in coastal waterways only. So you can see they're very specific kinds of activities. So now we turn to the big kahuna, waters of the United States. So the Clean Water Act is 45 years old this year, and we're still struggling with its jurisdiction, which is defined as waters of the United States. What we're struggling with, and what all the litigation is and has been about for many decades, is what are the waters that are covered by the Act? Do they include tributaries of tributaries? Do they include waters that are not permanent? Which adjacent waters do they include? Which wetlands? Which ditches? State and federal agencies, the regulated community, and the courts have grappled with uncertainty about which waters are regulated under the waters of the United States. There's tons of fascinating inside baseball about WOTUS that we don't have time to go into today. But in order to talk about it in the time we have together, we just really need to focus on three sets of definitions right now. One is the pre-2015, which I call the 2008 definition, which is the one that Joanna put up on the screen and is in place for some of the states still. And one is the 2015 rule, which is in place in some of the states and is under massive litigation in 16 federal district courts. And the 2019 WOTUS rule, which was just proposed in February, and the comment period closed in April.
And tons of comments, right?
There were 500,000 comments.
Yeah.
So if you have a friend at EPA who's reading those comments, you can feel sorry for them. Yeah. And they're what EPA is going through the comments now, and will come back to us with, I'm sure, as soon as they can. There was no extension granted on the comments, as there often is in a rulemaking of that size. So clearly there's a lot of impetus to get on with it. So this is the 2008, the pre-2015 list that actually you already saw with Joanna, and you can see, there's the usual suspects are waters used in the past or susceptible to use in interstate or foreign commerce. Okay, that's been around for a long time, including water subject to the ebb and flow of the tide. And interstate waters, been around for a long time. The territorial sea, been around for a long time. Then where you get into the debates and where people have been talking about it for a really long time are other waters that could affect interstate or foreign commerce. Well, how far are you going to go with that? Impoundments of waters of the United States. Just because you put an impoundment on a WOTUS doesn't mean it's no longer a WOTUS. And then tributaries. How far back into the tributaries do you want to go? Wetlands adjacent to all the waters that we just talked about can be a large amount of area to regulate. So this is still the law in almost half of the states as a result of the litigation on the 2015 rule. This is a schematic, another schematic from the Corps, relatively simple. The pre-2015 WOTUS includes a lot of jurisdictional determinations on a case-by-case basis by the Corps. based on the individual sites. And the determinations were sometimes viewed as inconsistent from district to district, or even within a district, which is what started the debates about whether a new rule was needed. And this is the course graphic of what its jurisdiction is, including the marking of an ordinary high water mark under the 2008 law. So the regulatory definition under pre-2015 was interpreted to cover many types of surface waters. WOTUS is generally surface waters. As Amanda's going to discuss further, the Clean Water Act doesn't generally cover groundwater, and there's a huge debate and another whole set of epic litigation raging about whether and how groundwater is regulated under the Clean Water Act, including a case that is before the Supreme Court this term that she'll talk about a little bit more. Now, on groundwater, the Safe Drinking Water Act protects water supplies, and state laws also often protect groundwater. So groundwater is not being completely ignored. This photo is a stream outside of Portland, Oregon, and it has wetlands adjacent to the stream. And this is all WOTUS under the pre-2015 definition. The pre-2015 definition excludes waste treatment systems and prior converted cropland. So in May of 2015, after years of litigation and debate, and a guidance that was issued by the Corps in 2011 that was later withdrawn by them following a hue and cry from every sector for rulemaking. It was that the only thing anyone agreed about the 2011 guidance is that there needed to be a rulemaking. The Clean Water Rule was finalized in 2015. Joanna mentioned the cooperative federalism. That's the hallmark of the Clean Water Act. And I just wanted you to see the language, that first paragraph that drives it. That's from the statute. Cooperative federalism comes into play heavily in considering the policies surrounding WOTUS. So prior to the 2015 rule, the Supreme Court had considered between 85 and 2006 jurisdiction and WOTUS under the Act in 3 cases. The first one's called Riverside Bayview, and they considered wetlands actually abutting navigable waters and concluded that they are jurisdictional. The second is called Swank. It's a great name. And they found that jurisdiction did not extend to ponds that are not adjacent to open water. There was an isolated pond on land, and the Corps had argued that because migratory birds stop and drink the water, that was enough of a connection to interstate commerce that they had regulatory authority under the Clean Water Act, and the Supreme Court said no. And so that's called the migratory bird rule, and it was invalidated. And then we have the third case, which was actually 2 consolidated cases, Rapanos and Carabel, where the Supreme Court considered wetlands adjacent to non-navigable water, tributaries of navigable waters. And Rapanos was a 5-4 decision. During the oral argument in Rapanos, the justices suggested that a rulemaking was needed. This was in 2006. And 3 of the justices in their written opinions, of which there were several on the case, also urged that the agencies promulgate a rule. And that's when they did the guidance that eventually was withdrawn. All the justices in Rapanos agreed that the Clean Water Act protects something more than traditional navigable waters, but there were a lot of differences about what the more is. Justice Scalia wrote for a plurality and said that there needed to be a direct hydrological connection and relatively permanent or surface connections for the water to come within jurisdiction. Justice Kennedy said that the waters with a significant nexus to navigable waters were jurisdictional, and the 4 dissents would have regulated all tributaries and adjacent wetlands. And Justice Scalia's articulation, it has been and is viewed as a more narrow set of waters than Justice Kennedy's. And so the agencies promulgated the 2015 Clean Water Rule, which mentions Justice Kennedy's significant nexus concept over 500 times. And so that's, that was based on his articulation. It redefined WOTUS for the first time in 25 years. And it was immediately challenged in 16 district courts and circuit courts involving 30 states, many other parties, including environmental groups, industry representatives, and this epic litigation has been ongoing since 2015 and is going on even today as we sit here talking about it. So what is the 2015 rules definition of WOTUS? Well, you're gonna notice and recall traditional navigable waters, interstate waters, territorial seas. We don't get into too much trouble about that, right? Impoundments of otherwise jurisdictional waters. The otherwise jurisdictional waters is where there's a debate. All the tributaries of the first 1 through 3, waters adjacent to 1 through 5, and then there were enumerated regional features with a significant nexus, and waters in the 100-year floodplain. This rule, as I said, was widely viewed as more expansive than the pre-2015 rule. And of course, depending on your perspective, it was appreciated or challenged. So in a nutshell, graphically, this is what the fight that's going on in court about the 2015 rule is about. This is just from the comments from Kansas, and there were a number of states who opposed the 2015 rule who filed different maps, but I thought that the Kansas one, first of all, it's sort of a neutral kind of state, and also it captured. This is what their jurisdiction looks like right now for WOTUS in Kansas under the pre-2015 rule. And this is what they thought that it would look like under the 2015 rule. And the concern, of course, is limited resources of the state to regulate where most states have taken over the NPDES permitting program, as Joanna mentioned. So we spent 2 years, first of all, figuring out where should we challenge the rule. Everyone filed in district and circuit courts just to make sure. There was a question of where it was, because the Clean Water Act, unlike the Clean Air Act, doesn't specify. And after an appeal or a writ, petition for writ of certiorari to the Supreme Court, from the 6 circuits having taken jurisdiction, the Supreme Court ruled in January of 2018 that everybody belongs in federal district court, not the circuit courts. So that's where they are, and that's where that litigation is going. Following the stay in February of 2017, in the meantime, a new administration issued a number of executive orders related to the Clean Water Act jurisdiction and ordered EPA and the Corps to review the Clean Water Rule and publish a proposed rule rescinding or revising it, and then also to consider a new rule that would be based on Justice Scalia's opinion in Rapanas, not Justice Kennedy's. And in July of 2017, the agencies issued a proposed rule that would have put everything back in place pre-2015 rule. The appeal on this rule was eventually dismissed by the agencies, and the second step, a rulemaking with a new rule, is what we now have in February, the 2019 rule. So where do we stand? This is current WOTUS regulation in the United States. The pre-2015 law, as a result of injunctions and litigation, currently still applies in 22 states, and the 2015 rule, still under litigation, currently applies in 28 states. So you have to know which box you fall in order to figure out in the state what set of rules you're applying for jurisdiction under the Clean Water Act at the moment. And this is EPA's map of what that looks like. The states that are colored blue have the 2015 rule, and the green is the pre-2015 rule. So the proposed WOTUS rule, as we said, the comment period closed on April 15, and there were 500,000 comments received and now being reviewed. And again, you're going to recognize some of this. There's waters that were or may be susceptible to use in interstate or foreign commerce, territorial seas, ebb and flow of the tides. There are tributaries of those waters. There is a new definition of ditches that is viewed as a much more narrow articulation, whereas before ditches were really considered on case by case. And water needs to be perennial or intermittent flow. The ephemeral flow is not part of WOTUS under the 2019 rule. And you've got impoundments and you've got adjacent wetlands to the rest of it. And it's considered narrower than the 2015 rule. They also did something that was a different approach, which excluded from WOTUS all of these features, including groundwater explicitly, which Amanda is going to talk about. In the 2019 rule, the preamble and the remarks by the EPA administrator said that they were going for state autonomy and would encourage the states to also take over the 404 permitting programs, pushing things down more to the states in water, and for clarity in the rule specificity. So it's very specific in what it enumerates. What's next? EPA is going to finalize the rule, likely this year, and then the litigation will begin on it. The first question will probably be whether the 2019 rule, once finalized, will be stayed nationwide or allowed to be implemented. And so we're just going to all have to wait and see. I just want to finally mention 401 state certification. Under the Clean Water, and this is also part of this whole cooperative federalism theme, under 401, no federal permit or license can issue unless the state certifies water quality standards are met or waives their certification right. And what happened last year, in the statute, there's the time period for the state to act says in a reasonable amount of time. with a parenthetical saying, which shall not exceed 1 year. And what was happening is, especially in a lot of hydro programs, the states were not able to act within 1 year, and so they had a sort of withdraw and resubmit kind of program going with the permittees, which would start the 1 year clock on the state's interpretation going again. So there were some facilities that were pending before FERC that had been on a 10-year cycle trying to get a state water quality certification. Well, the DC Circuit in January of 2019 basically said, no, that's not how the statute reads. And the case is called Hoopa Valley Tribe v. FERC. And they basically said, you have 1 year. And if it's not, this withdraw and resubmit program is not in keeping with the statute. So the agencies issued new guidance last week about how they were going to approach water certification, and they identified in the guidance that they're going to be doing a rulemaking, which should be coming up relatively soon, and include timelines, guidance, scope of certification, conditions, the kinds of materials that have to be submitted to the state in order to get a certification. That's what the guidance says. So with that, I am going to turn it over to Amanda, who's going to tell us everything else about the Clean Water Act.
Thank you. All right. So I am going to focus on the 402 permit program, and that is the NPDES or NPDES, National Pollutant Discharge Elimination System program. I'll start with a brief overview. I'm going to dig in a little more on point sources and discharges, permit types, the process, the elements of an NPDES permit, limits, which Joanna did a good job of covering. We'll talk about wet weather permitting and stormwater. Joanna already provided this definition. This is very important. She said it gives you a permit to pollute. I say it gives you a permit to discharge. Need a permit for discharge of pollutant, any addition of any pollutant to waters of the U.S., which Kathy has just covered, from any point source. So it is broad. If you want to know what pollutants are covered, both this section of the Clean Water Act and EPA regs will spell these out. It is pretty much everything. Conventional pollutants I'm going to talk more about because they apply to the municipal wastewater industry, and that's BOD, that's biochemical oxygen demand. So that's the oxygen required to break down the organic matter. Total suspended solids, fecal coliform, pH, and oil and grease. It also covers toxic pollutants and these non-conventional pollutants. As we already learned, point source, broad, any discernible, confined, and discrete conveyance. So this is the audience participation part. So those at home can participate as well. So let's go over some examples, and you shout out either it is a point source, yes, no, or it depends. So let's start with something easy. Let's go over here to the wastewater treatment. There's a pipe coming out of that wastewater treatment plant. I'm having trouble pointing at it, but you get the drift. Does that require an NPDES permit? Is it a point source? Yes. Okay. Stormwater discharges. If it's from an urbanized area is more than 50,000 people with a density of 1,000 people per square mile. If you have those characteristics, is this a point source governed by the NPDES program? I see some yeses. Yes, it is. Now, if you're out in the middle of nowhere, so let's say it's suburban and it does not meet those criteria, and you've got municipal stormwater runoff, does it require an NPDES permit? No. Okay, a little trickier up here, agricultural runoff. It depends. And that is where the confined animal feeding operation regs come into play. So if you have a certain head of livestock over a certain area, it's considered confined, and it is covered by the NPDES program. It wasn't originally. This came into play well after the 72 Act was enacted. Now, just general agricultural runoff, return flows from irrigation and fields, no, that is exempt from the Clean Water Act. Forestry, what do you think there? And here you think about forest roads. Lots of roads made through the hills to log, and whenever there's rain on those forest roads, it can channelize and run as if it were in a municipal pipe. No. And the reason this was actually a matter of dispute, and there was a Ninth Circuit case, and this went to the Supreme Court back in 2003. It was the Decker case. And as Kathy said, there's litigation on virtually every aspect of what we're talking about. But this is a particularly good lesson for EPA, because they, while this case was before the Supreme Court and had been scheduled for oral argument, EPA decided to finalize their rule on silviculture and exempting forest roads and forestry. And the Supreme Court, Chief Justice Roberts, lectured them about, it would have been nice had you told us before we scheduled oral argument. So that's not a good way to make friends with the Supreme Court. But those are exempt. And there are other examples that we'll get into during our discussions. So looking at discharges, you have your traditional point sources, and then these stormwater discharges we just talked about. It really depends on the nature of the stormwater discharges. Industrial stormwater discharges mostly are covered. Municipal, it's what municipal separate storm sewer systems are covered. Those came into play under the 87 amendments of the Clean Water Act. And for indirect discharges, I want to start with the pretreatment program, which Joanna referenced. And so this is the situation. So if you go back to this one, let's say you had outside the wastewater treatment plant, you have like a brewery, and it's discharging its wastewater not directly into whatever this water body is, but into the collection system that makes its way into the wastewater treatment plant. How about that? Does that require a point source NPDES permit? The answer is no, but it is still regulated under the pretreatment program. So they're discharging non-domestic waste into the collection system that then has to be handled by the wastewater treatment facility. So the wastewater entities like DC Water, they are regulated by the permitting authority, but they also regulate those within their collection systems that discharge to their system. So they can go back to that source and say, you're discharging too much BOD for us to be able to treat, or it's costing us more money to treat BOD, so you're going to have to pay more in your permit fees in order to do that. So it's a way for a wastewater facility to manage their their non-domestic dischargers. There's another indirect discharge issue that I'll bring up with groundwater next, but then turning to non-point source discharges, we've already talked a lot about cooperative federalism. That is a phrase that has come up a lot during the current administration, and returning to that original framework where EPA, the federal government, has a certain role and the states have a certain role, and you respect the state's role unless they're not doing their jobs. And we're seeing a lot of that right now in the philosophy of EPA and how they're regulating their programs. Okay, so let's talk about groundwater. Now, we already covered waters of the US, and there is no dispute that groundwater is not a water of the US. And there's a lot of confusion around this issue, even by courts who are trying to interpret this under a WOTUS analysis, looking at significant nexus and other phrases. And it is a jurisdictional question about the scope of the Clean Water Act, but it's not a jurisdictional question as in the jurisdiction of the water body. It's jurisdictional as in the scope of the Clean Water Act and covering this type of discharge. Is it point source? Is it non-point source? And the question really is, when you have pollutants that originate from a point source and they are conveyed to navigable waters, not directly from a point source discharging into the navigable waters, but through a non-point source such as groundwater, does this require an NPDES permit? Well, courts are split, and this is not a new debate. And this is, I mean, This is not as controversial as WOTUS. I think there were 13,000 comments on a recent EPA statement, not 50,000, but this is incredibly controversial. It's been disputed for decades, but the difference now is that we have some clear Court of Appeals circuit splits. In the Fourth Circuit, there was a case about petroleum leak. There was a leak, undisputed. That leak went into groundwater. It migrated to a water body. It was being addressed under RCRA, a different statute, but there was an environmental suit brought saying, okay, that you this is a violation of the Clean Water Act because you didn't have an NPDES permit for this discharge. This went up to the Fourth Circuit, and the Fourth Circuit ruled that because there is a direct hydrologic connection with the groundwater to that jurisdictional WOTUS, that surface water, it was a violation. The pipe that was ruptured was the point source. You would need a permit in order to make that discharge. Of course, in this case, you never have a permit because it was a broken pipe, but there was a violation. That's what the Fourth Circuit held. Then you go to the Ninth Circuit, and there they were looking at a case for a municipal wastewater treatment facility in Maui. This was a facility that had worked with the regulators for decades, and the regulators wanted to avoid an ocean discharge. So they constructed the facility. It was funded through federal dollars to construct injection wells. And they would treat the water, and they are treating the water. It's a tertiary treatment, so it's a high level, but you can't drink it. You can apply it to food crops. So they were reusing as much as they can, selling it for people who wanted to use it for irrigation, and the rest of it they were injecting into underground wells. That would then intermingle with groundwater, and over about a 2-mile landscape, it would then go into the Pacific Ocean along the shoreline in a more diffuse manner. So we had environmental groups who brought suit there. There was no question through a tracer study that the effluent was making its way over a period of time to the Pacific Ocean. The Ninth Circuit held that requires an NPDES permit. That is the case that has now before the Supreme Court, and that they will be hearing in the October term. Now, the problem here is that there's also now a Sixth Circuit decision, and this is a coal ash decision. And this is where you have these power plants that burn coal for energy, and they have coal residuals. And due to their proximity to water bodies, because they bring in water for the cooling process, these ponds where they put the residual are often right adjacent to a surface water of the US. And many times they're unlined. So there's the question of the contaminants getting into groundwater and then into that surface water. Well, the circuit there held no, that Congress never intended for the Clean Water Act to apply to these types of discharges, that there are other statutes. There are state laws that govern groundwater, and there's RCRA and other laws. So you have a real split here. And even among the courts who say you need a permit, there are different tests. So the Fourth Circuit used direct hydrologic connection. The Ninth Circuit, even though EPA, the Obama EPA, filed a brief there saying this is a clear direct hydrologic connection case, this Ninth Circuit said that language is found nowhere in the Clean Water Act, and therefore that test doesn't exist. And then the Ninth Circuit created their own test that was a fairly traceable test, that it was fairly traceable and in more than de minimis amounts, therefore there was liability under the Clean Water Act. So I can tell you that I do have an opinion here, just as somebody who works with the regulated community. It's a mess, and nobody really knows what is required. So at the very least, what the Supreme Court can do here, if they don't muck it up like they did in Rapanos, is give us some kind of clarity about whether the Clean Water Act applies to these types of discharges. But that remains to be seen. So we will, if Maui does not settle this case, it will go before the Supreme Court in the fall term, the next term. EPA, even though under the Obama administration had issued that, or they'd filed an amicus brief supporting a direct hydrologic connection stance, under this administration, they recently issued an interpretive statement. And they said the Clean Water Act does not apply here. So whatever weight that is given by the court, I don't think it will be given much deference. It's It's an interpretive statement. It's not rulemaking. And it is sort of like with each administration change, there seems to be a shift in policy. But EPA felt like they needed to get that out the door, and they did so. And just so you don't think that I completely don't care about groundwater discharges, we absolutely do. And we do feel like there is a robust system of federal and state laws that address this. So there really is no regulatory gap. And to try to extend the NPDES program, it really just doesn't work, because the NPDES program is meant to be a finite point that can be easily monitored, measured, and discharged from. And getting more into that, when you're looking at the NPDES program, we've already covered individual and general permits. To add a little more detail, your individuals are going to be just like it sounds, one discharger, one permit. General permits are where you have a category of discharges, like with your small MS4s, your small municipal separate storm sewer systems. All of them have similar characteristics. You can issue this general permit, and anybody who feels like they meet the criteria can do a notice of intent for coverage under that permit. And I do believe those are supposed to be renewed every 5 years, same as individual permits.
Mm-hmm.
They're issued by the permitting authority, which we already know that it's mostly going to be your state. Idaho has been approved for delegated authority, but they're not yet able to issue permits. It'll be another year or so before they start issuing permits. So once they do, really, it's only Massachusetts, New Hampshire, and New Mexico where you're going to use have the EPA actually doing it. We already talked about EPA, regardless, has oversight of those permits and can object in certain circumstances. Every permit, even general permits, have to be put out for public notice and opened up for a minimum of 30 days for comment. If there's significant public interest, then the regulatory agency can grant a hearing. Once the final permit is issued, then there's administrative and judicial avenues for challenging that permit if you're a stakeholder. That means you can be the permit holder and you don't like what limits you have in your permit, or you could be somebody in the community or an environmental group that can challenge it. And while permit terms shall not exceed 5 years, in reality they often do, because of resources. States don't reissue them every 5 years. They get administratively continued. It's an issue. There's a backlog of permits out there in almost every state, and in states where EPA issues the permits that are due for renewal. So when it gets to permit elements, effluent limits, we've already talked about. You'll have monitoring and reporting requirements. Jana covered that. Best management practices come into play in stormwater permits. We'll cover that. The limitations will be technology-based, water quality-based, or can be based on a TMDL. Joanna, again, covered this. I will tell you more about secondary treatment standards. So the Clean Water Act doesn't care what kind of technology you actually use, like in a sewer treatment plant, what your processes are. What they care about is at the end of the pipe that you're meeting the standards for, and in this case, the category is POTW, publicly owned treatment works. You've got pH limits, you've got that biochemical oxygen demand, suspended solids. And backsliding, I don't know if you covered this, backsliding means that if you issue a new permit, it's not going to be less stringent than your old permit. So if your technology-based effluent limits are not enough to protect the designated use, that's when the permitting authority is required to look at those water quality standards, whether they be narrative or numeric, and do an analysis to determine whether the discharge is going to violate those. And Joanna covered that in good detail, so I'm going to skip to TMDLs, which she also covered. But what I want to say here, so this is another step. So if you have a water body that is impaired, and states are required to look at their waters and designate them, it's under 303D of the Clean Water Act. They designate streams that are impaired, and it'll be impaired for a certain pollutant. So you might have something that's impaired for suspended solids or something like that. And then what's supposed to happen next is the development of this pollution diet, a total maximum daily load. So that really looks at your water body, which is ideal. So you look at your water body and you say, okay, it's impaired for this. Here are all the sources, and this is how much each of these sources are going to have to reduce their loading by in order to get this stream healthy again and remove it from that impaired list. And the beauty of a TMDL is that you can get at non-point sources. So this happened with the Chesapeake Bay TMDL. And here you had a multi-state TMDL. So EPA actually did the TMDL. It then created waste load allocations that were attributable to each state. And for these states, there were non-point sources such as agriculture, which are normally exempt from the Clean Water Act, who had then a role in reductions that the state had the authority under the TMDL to go after. The Farm Bureau sued. This went all the way up to the Second Circuit, and then they petitioned the Supreme Court for review of this. The Supreme Court denied. But the Second Circuit held that that is perfectly legal under the Clean Water Act to attribute a load to non-point sources. So this is a way where the Clean Water Act normally exempt those activities to where you can get to them through a TMDL process. And again, just so you don't think that my organization's evil, we participated on the side of the Chesapeake Bay and were an intervener in that case. So getting more into municipal wastewater management and treatment, I already talked a little bit about the treatment processes. We'll go over a little more of that. Very important: combined sewer overflows, sanitary sewer overflows, peak wet weather, flow management, or blending. I'll talk a bit about integrated planning, and I've already covered pre-treatment. This is a video that's on this site. It's an engineer site, the Short Sleeve Club, and I watch a lot of wastewater treatment videos, and I thought this one was particularly charming and well done. Now, it does have the poop emoji through the process and then equaling a glass of water. And just so you know that most treatment plants don't treat to drinking water standards where you can drink the effluent. Now, in arid regions, we're seeing more and more of that because of water scarcity, that you'll have direct potable reuse. But like here locally, DC Water, they treat their wastewater very highly, but they discharge it into the Potomac, and then eventually there are water intakes that bring the water back in and treat it to drinking water standards. So that part's a little misleading, but the actual video itself is fascinating to look at the primary treatment, secondary treatment, tertiary treatment. And this is, even though you may not be in the wastewater industry, if you're interested in the Clean Water Act, wastewater treatment is really, it's where it's at. This is why we live in the society we live in, free of disease, and it is incredibly important, and we're all part of the problem and part of the solution since you all pay wastewater fees. So watch a video, or even better, go for a sewage treatment plant tour. My summer interns are in the back, and we're going to be going tomorrow to Alexandria Renew, and then on Friday to DC Water. They welcome the public, they do great tours, and I promise you will learn a lot that you can impress your friends with or embarrass them. Okay, so let's get into some wet weather flows. Combined sewer systems. That is where, and this happens a lot in the eastern part of the country, older systems. And at the time that these systems were created, turn of the last century, it was considered good engineering because you have all your wastewater, so all the drains from this building and homes and residences going into a collection system that's underground. And then you also have out on the street, you have catch basins for stormwater. That's going into the same system. So you've got stormwater and your domestic sewage, and also that industrial, non-domestic sewage, all in one pipe. Now, during non-wet weather, during dry weather, your treatment plant will have the capacity to treat all that, and everything's good. But what happens when it starts raining a lot? You exceed the capacity of the plant, and you cannot feed more flow through your plant than what it is designed for because of the secondary treatment process, which involves bacteria, bugs. You'll wash out your bugs, and then your treatment plant will be offline. So plants know how much they can take in. And with a combined system, they have a constructed diversion. So once you get to a certain flow, you have a diversion of its wastewater mixed with stormwater that goes into surface waters. Now, those are prohibited under the Clean Water Act. There is a combined sewer overflow policy that was enacted in '94, and that was actually codified into the Clean Water Act. It is part of the Clean Water Act. It talks about how these systems, how these overflows have to be addressed, and many of them have been addressed, and I'll talk about those in a minute through what are called consent decrees. But before we get to that, let's talk about sanitary, separate storm sewer systems and sanitary sewer overflows. So in newer areas, we're not building new combined systems anymore. So in separate systems, you have everything separate. Your stormwater is separate from your wastewater and your industrial water. But what happens is you have systems that are not airtight. You have roots that grow into pipes that allows water in. So you have, during wet weather events, you have water coming into those pipes, and those can cause overflows. There is not an SSO policy, and therefore they're considered, if they reach WOTUS, Waters of the U.S., they're considered prohibited under the Clean Water Act. Here's a map, this is on EPA's website, of combined sewer systems. You see how they're concentrated. These are large ones serving populations of more than 50,000 people, concentrated in the Northeast, the Midwest, and then in the Pacific Northwest. And they are largely addressed, these large systems. So of a universe of 213 systems as of fiscal year 2018, 209 of them have been addressed, with 4 having been enforced against, where the enforcement action has just been initiated. For SSOs, much more ubiquitous around the country, they're everywhere, and here they're looking at large means more than 10 million gallons per day, and of a universe of 1,103, you have 1,014 that have been addressed, with 59 having initiated enforcement actions. So this has been, in the past, since 2000, this has been a big, these overflows have been a big enforcement and compliance initiative for EPA. But just recently they were proposed for removal. For every 3 years they come out with these initiatives, so it'll be for the next fiscal year, which begins in October. And that is because of these statistics here. Largely EPA has been able to address these. Now these are very, very long-term projects, and they're often under what's called a consent decree, and that's just a judicial settlement that for over, say, 20 years, a community is working and investing millions and billions of dollars into infrastructure upgrades, storage, tunnels, like in DC Water's case. So it takes time to resolve these issues, but they are on the path for being resolved. Okay, so peak flow management is blending, and this is where you have peak flows coming to your plant. Another way to deal with this is that you have it go through part of your treatment, route it around secondary. You often recombine and disinfect and then discharge, and you have to meet your effluent limits at the point of discharge or you're in violation. But most times they do meet their limits, and there has not been a rule on this, but EPA has initiated rulemaking. And since I'm running out of time, I'm going to skip through that, I want to talk about this integrated planning, great success story. This was in Congress, so in a Congress where nothing gets passed. We had the House pass this bill 351 to 10 and passed by unanimous consent in the Senate, signed by the President in January. And what this does is that it says, okay, municipalities, we understand, EPA understands that you have many priorities, and you have not a finite amount of public resources, and you can't do everything all at once. So determine what your priorities are. Where are you going to get the most bang for your buck from an environmental and public health standpoint? Do those first, and then sequence everything out. Push out those things that may still be a Clean Water Act obligation, but that are just not going to do much for water quality improvement or public health. Push that off, and maybe by the time you have to address it, laws will change or you'll have more resources. So, so it's really a common sense approach to the fact that you don't have enough money to do everything. And so that is now incorporated in the Clean Water Act. So it shows that we can actually make meaningful changes to environmental statutes. So it is a success story in what is a kind of sad time in politics in DC. Stormwater, I've got 3 minutes, so I'm going to run through these. This I put up here because, first of all, for municipal separate storm sewer systems, one of the minimum control measures that you have to comply with is public education. But you'll find so many of these that talk about stormwater. And it's important because the Clean Water Act was mostly designed for your traditional point sources. Stormwater, while it's an MS4, is considered a point source. It's a lot harder to regulate, and stormwater everywhere is now, with the point sources largely resolved, is often the leading cause of impairment. And it contributes a lot of nasty stuff to our waterways. So there's some really good education pieces out there. So this is the language in the Clean Water Act that got to phase 1 communities. And those are your larger, medium and large communities. Mediums over 100,000, large is over 250,000. This was in 1990 that this program came out saying, okay, you've got to get a permit. And for phase 1 communities, it's mostly an individual permit. And then you've got phase 2 communities, and there's the language that it gave EPA authority to regulate small communities of less than 100,000. Still has to meet that urbanized area that I described earlier. This is often governed by general permits. And then the applicable compliance standards. So here, the Clean Water Act, it differentiated. So for industrial discharges, meet all applicable provisions. So that means comply with water quality standards, designated use, maintain designated use. For municipal discharges, it put in this language about maximum extent practicable. Now, there is a lot of litigation and dispute about this language because it all has to do with an Oxford comma, and we can't get into it now, but it's really fascinating. So you know, there's EPA and some environmental groups who are saying that that the standard really is meeting water quality standards, and we think it was a lesser standard. Maximum extent practicable is still a very high standard. It means that you're doing everything practical. What it does is it considers cost, whereas most of the Clean Water Act does not take cost in consideration. I do not have time to cover this, but if you want an example of what goes into an MS4 stormwater management plan, this Pennsylvania resource is a really good one. Residual designation authority, this is something very clever that the environmental community is doing, particularly NRDC. This is a sort of a catch-all. So if the EPA administrator determines that a stormwater discharge contributes to a violation of a water quality standard, or is otherwise a significant contributor of pollutants, they can use their authority to designate them as a contributor and require a permit. And this last provision is important. Any person may petition the agency to require such a permit, and NRDC has been doing this. And there's a case right now in Baltimore where EPA, there was just a trade press article yesterday, EPA had lost on there. They denied the petition, but they didn't make a determination about whether the site contributed to water quality standards violation. And the decision said they have to at least consider that. So EPA had appealed it, but they withdrew that appeal. So now I guess they're going to go back and reconsider that petition. Oil and gas and mining operations largely covered under 311, and so largely exempt unless the stormwater is contaminated by overburden and byproducts. And I already covered silviculture. All right, that's it. I think we have a few minutes for questions.
Thank you so much. We're going to open questions up to the room before going to the online questions. Do you have any questions for the panel from inside the room? No? Okay, we'll kick things off with some online questions. This one's directed to yourself, Joanna. Why are coral reefs considered a point source?
Because they are a discernible point that you can sort of draw a line around the coral reef and say there is something that is regulated by the Clean Water Act that's being emitted into navigable water or other waters that we can hopefully agree that coral reefs tend to be an ocean, so there's no controversy there, to the extent that it's contributing to the degradation of water quality, which again is sort of the goal of the Clean Water Act. So it's a funky thing, and I wouldn't say it's something that I know I've ever worked on, but it's just because it's something that you can point to that's clearly a point source that's emitting something that, you know, could be emitting something that could be regulated by the Clean Water Act. That's my short answer. I guess anything else to add.
Fantastic. We have another question for Kathy. You mentioned 404 fill and dredge. Why are only 2 states delegated within that?
Well, it's not because EPA doesn't want to delegate. The states have not stepped up. And I really do think we're talking about resources here and cost. I mean, it's a lot to manage a program like that. And a lot of the states don't have the funding.
Can I add to that?
Yeah.
I worked for the state of Kentucky, and we went through a year-long process of determining whether the state of Kentucky should take over the 404 program. And in the end, we didn't. And the idea was, by taking it over, we hope to cut down on the permit time. So it's for individual permits, it takes many years to get them. But after analyzing it for a long period of time with all the stakeholders at the table, it wasn't clear that we could make a dent in the time frame because of a resource issue.
Yeah, and I guess I would just add something else. I mean, there's a lot of expertise that the Corps has had for many
Sure.
decades
Yeah.
that states do not have in administration of this program, and that's an ongoing challenge.
Yeah, true.
Fantastic. We have another question online. Believe it's directed toward Kathy. Does the Army Corps have to do any EA or EIS for the new WOTUS finalized rule?
Actually, not for the rule itself. No.
Okay. We have another question submitted through online. In the face of, I guess, climate change and energy use, how do you believe, this is for the general panel, that the Clean Water Act as well as WOTUS will evolve, over time, or will they adapt to these, I guess, impending threats?
Yeah, it's a good question. They certainly did not envision climate change when they were enacted. But I know that under the Clean Water Act, particularly for facility planning, like for wastewater facilities, that should come into play. How you're siting facilities, looking at sea level rise. So it's.
No, and I was going to say, Amanda, isn't it, I mean, I know that this came up in Miami, right? I mean, I do think that particularly some of the coastal cities who in the east, in the wetter, parts of the country, are kind of grappling with this as they plan, size of facilities, where to put facilities, and again, an area that I think that the public may not always be aware, and I think sometimes even in our purview, we may not be aware, things like New Orleans and what happened and planning and what might be done differently. I think this is something that everyone is thinking about because sea levels are rising and there's water in places where it wasn't, and boundaries are changing and conditions are changing, and it's something that we are all muddling through together, quite frankly.
And when you think about integrated planning, that was brought up in the context of CSOs, but really it applies to anytime you're looking at a lot of obligations. And that's the conversation you should be having with your regulators, is that, okay, we've got all these things, including resiliency planning and climate change impacts. How best can we spend our resources? And so that would be something that hopefully could be brought to the negotiating table with your regulators to determine how you spend your money.
There are a variety of facilities too that all come into play, and climate change effects that impact water, and a lot of siting laws are considering it. There's, activities by companies and reporting requirements in the coastal cities. Joanna mentioned, I live in New York City. There's a lot of focus at the state and local level about resiliency and how we're going to cope with what happened in Hurricane Sandy. If it comes back in the future, the tip of Manhattan was underwater. There's some fantastic photos of the subways that they look like aquariums underneath. And of course, half the island was completely out of power and water. So there's a lot going on. I mean, it may not be under strictly the Clean Water Act, but there's a lot of thinking going on under the whole package of law that affects how water is impacting and could impact, and extreme weather, and what climate change requires.
Thank you. We have one last question for in the room.
Thank you so much. I was just reading this case. I'm an intern here. Browner v. Albuquerque, where basically a tribe set its own water quality standard, and it basically compelled the city to comply with it. That made me think about states, I guess, neighboring states or tribes and states where they have varying water quality standards. Are there like negotiation mechanisms to try to resolve that so the courts don't have to deal with kind of making one comply with the other?
I'm just thinking of I mean, I think again, sometimes we have situations where more than one state, right, is affected in a particular situation, or tribes and states. And I mean, I think there are certainly situations where you have essentially multiple entities, like the Mississippi River is one that I know that I've been involved with, where you have something along one portion of the river, but there's a different state. And but I think it's an ongoing challenge, because at the end of the day, we are all dealing with individual sites, individual cases, and sort of how everything fits together, within a particular state and then between states and tribes is a different overlay. I think there's not one set way of doing things that I've seen anyway. I don't know if you have any thoughts.
Yeah, and
Yeah.
anything to add?
Right. Are there any last minute questions real quick? I think this is the last question.
Thanks. First, thank you for speaking today. I was also wondering what type of interplay the Clean Water Act has with other regulations. So for example, you talked about the Chesapeake Bay a lot, and a lot of the nitrogen deposition actually comes from atmospheric sources. So is there any interplay between this regulation and other regulations?
I mean, yes, I think is the short answer. Certainly, I think that there are always challenges, but for example, EPA and states will do multimedia inspections of various facilities. For example, refinery, there might be water issues, there might be air issues, and depending on the situation that you're dealing with and the knowledge that you have. And again, I hate people keep mentioning resource constraints. I think there's an there's an effort to try to address things holistically wherever possible. But certainly, I know EPA and DOJ, but states as well, will take multimedia enforcement actions, do multimedia inspections when they have information that there are problems that are not just under, an air permit, but then there's a water permit, and they'll look at those things together. So. And
it needs to happen a lot more, because these things, they are dealt with by different offices in a vacuum with specialty in a particular statute. And it's coming up more and more in our conferences. We look at interplay with Endangered Species Act and Safe Drinking Water Act. And one quick example is with lead reduction and corrosion control. There are things that you can do on the drinking water side where you add phosphorus, and it reduces the lead corrosion from pipes, but then you've got a lot more phosphorus that is then going to your treatment plant. So who is trying to reduce phosphorus to a phosphorus impaired stream. So by looking at that holistically and say, is there another measure where you're not adding phosphorus that could reduce corrosion and limit your lead exposure? So it's, it's looking at those things, not in a silo, but saying, okay, look at the entire watershed, the entire area, and what you're trying to achieve. So we're getting better, but we're not quite there yet.
It's complex.
It is.
And I think, we have to a certain extent a patchwork of environmental laws, and different countries and different places approach things differently. Europe, for example, and those are ongoing conversations and lessons that hopefully our, regulators are talking to each other and learning from each other.
Thank you. And with that, I'd like to thank you all for your participation for joining us today, and thank you for your thoughtful questions. We hope you continue to think about the numerous factors of the Clean Water Act, and we're so grateful for your participation in our annual summer school series. And we hope to welcome you all back to the basics of land use law next Tuesday. I want to extend a huge thank you to our fantastic panel, Amanda, Joanna, and Kathy. You guys were excellent, and thank you so much for lending your expertise to today's summer school session. Thank you.
My pleasure.